any event, so okay, so they have the cautious statute, which I guess is cautious argument, which is confusing. Right. The uniformity argument, which is kind of confusing because how do you do that? And then what else did they argue?
So money, of course, is something everybody's interested in, and they were saying that DOMA was fiscally conservative. Let's protect the public coffers. We don't know what the effect is of marriage and allowing same-sex couples to marry, and it could cost money. They didn't study it. They did not ask anybody to tell them whether it would cost money. They just said all these couples could marry, maybe it would cost us money. Now, it turns out that was wrong, that if, in fact, the federal government would recognize all marriages of same-sex couples, about an extra $1 billion a year would flow, or $1 billion would flow into the federal treasury in the time period they were looking at, because basically some couples would pay more in taxes, some would pay less, some would qualify for Medicaid, some wouldn't qualify for Medicaid. But when you go across all the programs with Social Security, Medicare, Medicaid, taxes, and it turns out DOMA affects over 1,100 rights and responsibilities, that money would go to the federal government.
So you guys are arguing for gay people to pay more money into the federal government,
but get some benefits at the same time.
That's right, and get some security for families.
Well, I think that point that you just made is incredibly important. We have a social safety net in this country, much of which is triggered by the marriage relationship, and from which gay couples are completely excluded. And Social Security is a great example of that. I mean, here, these couples had paid into Social Security their entire working lives, 40, plus years for some of these couples. And yet they couldn't rely on the same basic protections for their spouse that other people could.
It's almost unthinkable. What's sad is a lot of people, and we've had estate planners on this show, and it's just very sad when they come in here and they say, yeah, people get married. And then they're like, oh, here's my house, put your name on the deed.
Right.
And the spouse, the same-sex spouse, is all of a sudden hit with, the spouse giving is hit with a gift tax. Right. I mean, there's all these things that go into place. If you, federal estate tax laws, yes. I mean, there's just so many different ways. And it just goes back to what we argued way back when. There's a difference between marriage and civil union.
Right. So a couple of points I want to just make clear about. So one is that same-sex couples marry for the same reasons everybody else does. They marry for love and for relationship recognition, and it also happens to come with these rights and responsibilities. But also, it's not enough to say that a law will save money, because you can pass lots of laws that would save money. You could say, well, we're only going to recognize marriages on the odd days of the week, and we're not going to recognize every 20th marriage in Montana. Like, what's the why? So you can save money a lot of ways. There has to be a reason why we're going to save money on the backs of a particular group of people, and DOMA doesn't answer that question. So that saying we're going to save money by itself is not enough. And as I say, it turns out that DOMA costs the federal government money.
Yeah. So, and I think one of my pet peeves is because I do a lot of work with children in the court system, and same-sex couples have been adopting children out of foster care. That saves a lot of money to society and gives these children a safe, permanent, loving home. And all of these federal benefits are not only for the couples, but the children.
Right. That's right.
And that's critical. In the companion case, the Prop 8 case, Justice Kennedy was kind enough to recognize that, at least with respect to 40,000 children in same-sex couples households in California. And the New York Times did an article in October on this issue, that since same-sex couples have been allowed to marry in 9 states, almost 17,000 children have been adopted out of foster care into these homes, into a permanent, loving home. I mean, this is a win-win.
That is a win for those kids.
So that's their argument, and I guess we see why they lost. Unfortunately, we'll see what the Supreme Court does. Right. But what are the possible outcomes here?
Well, the one last argument they made was child rearing, and that it's best for children to be raised by their biological mother and father, to be raised in a home with different gender people, et cetera. And there's a ton of studies out there, 50 years worth of research that basically says that children raised, if you compare apples and apples, where you intact a heterosexual family or different sex couple raising children and an intact same-sex couple raising the children they brought into this world, the children fare equally well.
Well, the American Pediatrics Association said as much.
That's right.
And again, in a country with half a million, over 500,000 children languishing in foster care,
Right.
that's a cruel argument to make. It's a very cruel argument.
Well, and DOMA doesn't actually do anything about children. It just defines marriage. So it doesn't actually do anything about, children are going to be raised by same-sex couples regardless.
Yeah.
So it's just beside the point.
It provides protections.
Right.
Okay. So there you go. So what are the possible outcomes in this case?
Okay. There are roughly three possible outcomes. So one is a technical legal outcome, which is should this case even be before the Supreme Court right now? And just briefly, because the executive branch stopped defending, the question is there a live controversy before the court? And I think the answer to that, well, our argument is that there is, because the administration is still holding Ms. Windsor's money. She had to pay a large estate tax because she was married to a woman instead of a man. And the administration is actually saying if it's just really rational review, DOMA is constitutional. They're saying if it's any kind of extra look, DOMA is not constitutional. So they are still actually litigating the case. But if for some reason the federal government did not have the right to go to the Supreme Court, then the House of Representatives has been defending the case. And there's actually an issue with what they're standing to, which is one is do they have an interest aside from the general public to be there? There's actually a second issue, which is it's just the House, it's not the House and the Senate, so can the House be there by itself? And then the third issue is the House didn't actually vote to intervene in this lawsuit. It was just a leadership committee. It's called the Bipartisan Legal Advisory Group of the House of Representatives. It has 3 members of the majority and 2 of the minority party. So the 3 Republican members voted to litigate the case, and the 2 Democrats voted against litigating the case. But there was no rule in place at the time they intervened authorizing that little group to act for the House of Representatives. After the Supreme Court took the case, they passed a procedural rule saying that BLAG was authorized to represent the House. But nobody knows what the Supreme Court will think of that.
Oh, there you go.
So that's a procedural off-ramp, we're calling that, where the Supreme Court does not decide on the merits of the argument. There are 2 merits outcomes. One is DOMA is struck down, and all legal marriages of same-sex couples would then be recognized by the federal government. And the other, of course, is that DOMA is upheld. It's found to be constitutional, and then we'll continue on as we've been, where we have these, Massachusetts will have 2 classes of marriage that are recognized by the federal government, and then these sort of, as one of the justices called them, skim milk marriages.
Skim milk. Justice Ginsburg.
Yes.
I love that.
Yes.
So, okay. And then there was also the other argument brought by some of the states, like Attorney General Martha Coakley, which was that this is a states' rights issue.
Yes.
We've covered that. Basically, states have been defining marriage, and
Right.
all of a sudden the federal government comes in.
Right, that's right.
So it seemed like Justice Kennedy liked that argument.
Yes, that's a sort of a federalism argument that the federal government really does not have any business in the marriage business, that it really is a role, historically it's always been a role of the states, and the federal government should stay out of it.
It's what we call 10th Amendment argument, I guess.
Yes.
So, okay. So I only have a minute left. So there was the companion, the Windsor case. And that
The
was
Perry case, the
Perry
California case, yeah.
That's right.
So real briefly, that is whether or not, whether Proposition 8 that was passed out in California in 2008 is constitutional. That's a complicated case. There are several different outcomes. Based on the oral, I've been saying there are 5 outcomes, but it turns out there's a 6th one, which is if the Supreme Court says it's dismissed as improvidently granted, like they just decide, we're not going to decide this case, then it would go back to the Ninth Circuit and we would have marriage in California, which actually would be a big win.
That would be a big win.
They could say that Prop 8 was constitutional, in which case no marriage in California until there's a new ballot initiative, or they could do something somewhere in the middle. They could find that on the unique circumstances of getting marriage and then taking it away in California, that's unconstitutional. You'd get just marriage in California. They could that'd be a one-state solution. There's a 9-state solution, which is anyone who had civil unions and just hasn't taken that last step to giving marriage, that they would say that's not constitutional. So California and all the civil union states would then have marriage. And then, of course, there's a 50-state solution, which is just our Loving versus Virginia, we get marriage.
Loving versus Virginia, which ruled that banning interracial marriage, a great name, Loving v. Virginia,
Yeah.
that the interracial marriage was unconstitutional. Marriage is a fundamental right, and of course, that should be the argument here, one would think. But there you go. Thank you very much, Vicky, for coming in here and explaining all that. There's apparently a lot more there.
There is.
So thank you again. You've been watching Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. We're brought to you live the third Wednesday of every month at 4 p.m. In closing, it's 2 days past the horrible bombing on Patriots Day. Our thoughts and prayers are with all the people injured. God bless them. God bless America. Thank you.